they gave us, you're supposed to exchange your documents, your exhibits on the Friday before the Monday trial, and he gave it to me on a flash drive, right? And I'm bringing in. I'm from Monterey. I'm bringing in boxes.
Absolutely.
So I give him the boxes, and here's a flash drive. So I've got to now the weekend before the trial. I got to download it. I got to go through everything. I've got to make copies of it. And he did that intentionally.
Sure. Of course. Sure.
So
give you a little adjutant.
Yeah, I let him know that I was going to go to the court and seek sanctions for him not giving me hard copies of it. And he said, "Well, let's see if we can work this out." And he had already told me I couldn't use his technology. You guys are on your own. This is our technology.
Wow.
So on the weekend before the trial, we worked out a deal where I got to use their technology in return for my not seeking sanctions. And that was really helpful because we had their main guy from Japan, who I had videotaped his deposition. It was a 2-day deposition. He didn't show. I couldn't force him to come because he was in Japan. You can't force him to come. And they did not want him there.
Yeah.
But because I videotaped it, it was really important. I showed 6 hours of videotaped deposition testimony that I'd pulled out to the jury, put them all to sleep. But in the closing argument, I was able to flash up there on their technology the quotes that this guy said, where he said, I'd put my own daughter in that middle seat. There was nothing unsafe about it. And then the next quote was, well, we never tested it for safety because we didn't think it was unsafe.
We didn't think.
Yeah, and then they didn't think.
Yeah, right.
So it was that was the turning point. Was that those books? I think, coupled with the arrogance of the lawyers. He tried to cross-examine Chelsea.
Oh, he did.
Chelsea is such a wonderful person.
Yeah, it's real sweet.
Real sweet, and a lot of sympathy for her.
Sure.
You may not. If you were a juror, you may not think she was entitled to something, but you liked her.
Yes.
She was a wonderful person, and he decided to cross-examine her. That was huge mistake. And he tried to play games. He put up a videotape of her testifying that for being on television she was in a reality TV show for a couple seasons, and there she was in the car, and she had her shoulder harness off her shoulder, and this is after he had asked her, to this day, do you still wear your shoulder harness? And she said, yes, I wouldn't go anywhere without it. And he said, so you care about your safety? Yes, I do. Well, isn't it true you really don't care about your safety? And she said, no, I care about my safety. And then he flashes up this video. Yeah. And he said, well, here's a good example of you not caring about your safety. And it showed the shoulder harness off her shoulder. And we knew what it was. It was, she had a microphone on her lapel. And the director had told her to take it off her shoulder so that it wasn't rubbing up against the microphone so they could hear her talk. So it had nothing to do with the lack of safety.
Right.
And he looked like a fool because he was attacking her when in fact there was a reason for it. And he did that again. He put up a couple of snippets from a television deal where she said she didn't care about her safety. And he showed 6 seconds of her saying that. He didn't show the whole thing where she was crying, and she said, at the time, I didn't care about my safety because I was a kid.
So they just used a little portion.
Yeah, and then they came back and bit him. So it was great experience.
Wow! Congratulations. That would have been awesome to see
smart.
that. How long did it go on?
Smart, Bob.
How long was that trial?
5 weeks. 5 weeks.
Well, you did your homework, as they say.
I'll tell you what, for the 6 months to a year preceding that, I didn't work on anything else. I had a great team. I mean, I had people there that were really helpful. I couldn't have done it by myself. They had, like I said, they had 5 lawyers.
The research you did is
we did
awesome.
A lot of research, and they had, I'll tell you how technologically savvy they were, or advanced they were. They had a paralegal or a secretary in the audience. And if my expert was testifying on the stand, she would be putting into her computer the testimony, and then she would print out, they had a printer there, and they would print out prior testimony in prior cases that they had in their database where it was contradictory. And they would hand the attorney this contradictory testimony from a case 5 years earlier, and they would cross-examine my expert and say, well, isn't it true 5 years ago you said this?
Yeah.
Wow.
Well, they did their homework, too, to a point, right?
Yeah.
So after it's all over, what do you do? Did you take some time off or what?
I've cut back, and now I pick and choose the cases that I want to work on and take the interesting or more complex cases and work on it. But I've got a great team at L&G. We've got a great team of paralegals, a great team of litigation attorneys, and David Balch, who's been around here for some time, heads our litigation team. And so I work with David on cases that I want to work with, and then we've got a couple of other young lawyers, and Matt Rankin and Nevin Miller and Sergio Parra. We got a good group.
Bob, how's that work now when you win a settlement? They send you a check right away, or how's that work?
Insurance companies send a check right away?
Yeah.
That's an oxymoron. No, they, what you mean with regard to Hill or just generally?
No, just generally.
Generally speaking, you settle a case and you get your check within 30 days
okay.
of it. Yeah, it's not
I don't know
bad.
those things.
So you don't want to know.
Oh,
you don't
okay.
want to. It's much better to have your health than to file a lawsuit.
Oh yeah, no.
So
I don't.
do you when people take you on? Is it one of these? Do you hear about or see these things on TV? Unless we win,
Oh, those are contingencies, right?
we have to win in order.
So
you
a personal
have to
injury
pay
case is handled on a contingency fee basis. What that means is the attorney thinks that there's a case.
Sure.
So you take the case and you get your fee based upon what you recover for the client. So, and there are times where you recover, you don't recover, or you don't recover enough.
So that's you're on your own.
That's why it's a contingency
Right.
fee. And most people don't have the ability to pay for an attorney by the hour, and the result is that by having a contingency fee matter, they are able to proceed and not have any risk themselves for having to pay attorney's fees. So that's how it works.
Very interesting, Bob. You got it together, buddy.
Well, I don't know about that, but it's been a good career.
So it's L&G LLP attorneys at law, Gillis, Rosenthal, Johnson, Ravella, Rederer, and Sullivan. L&G LLP attorneys at law. So check them out online. Get more information. You might need them sometime.
Gentlemen, it's been
Thanks,
a pleasure.
Bob.
It's been
Thanks,
a pleasure.
Bob.
You're good.
Go
As they
Rockies.
say. Go A's. Do we play them, Dave? I don't know. Thanks, Bob.
Thanks, Bob.